S14G1202, Cecily Considine versus George W. Murphy et al. Cecily Considine for herself, Joe Kigma for appellees.
May proceed when ready.
Good morning. I'm Cecily Considine. I'm a pro se litigant in a civil case. I'd like to first thank Justice Kelly for his time and his travels today for coming here. I'm here from a case from Cherokee County where the appellant, which is me, filed a civil suit against a receiver. The suit was for breach of contract. It was for breach of fiduciary duty, gross negligence, willful and wanton misconduct, and failure to follow court orders. The trial court dismissed the case based on subject matter jurisdiction on grounds of official immunity. The Court of Appeals upheld this dismissal requiring evidence of malice, they were requiring at the motion to dismiss stage. What we have is an overreaching of official immunity for a receiver, where the trial court has declared a receiver immune from gross negligence and willful misconduct, where the duties that were outlined in court orders are being misdefined as discretionary when in fact some of those duties were in fact ministerial. We also have to look at the disregard for the language of the court orders and an engagement letter that was from the defendant that both state that he is liable for gross negligence and willful misconduct. And cloaking him with a veil of official immunity allows him to duck under those standards. I'd like to give the shortest review that I possibly can on why a receiver was appointed. The appellant, myself, had a very successful business that started in 1997. In 2007, 10 years later, one of the staff members ran an ad in the Cherokee Tribune for 7 days, Mike Affatato doing business as model master. With this ad, he was able to go to banks, open up bank accounts. He rerouted my mail. He formed a clone of the company. He, with other people of the company, a couple individuals, diverted fund and engaged in other activities that are textbook RICO. The details of those cases, of course, are a different case, but while I was out of town, they emptied my place of business. I appealed to the civil court and asked for a receiver. I needed someone to protect, marshal the assets, to be someone that would either okay or stop things being looted. When I petitioned for the court on September 3rd, 2008, a consent order was executed that is now being referred to as the appointing order for the receiver. It details duties for the receiver. The duties were to marshal the assets, deposit all of the funds, and make specific payments, including specific payments on personal property that belonged to me, that had list pendings on them. Where we are today is reviewing when a court-appointed receiver is immune from suit. In this case, the other side is mixing officer of the court and public officer. They, in fact, are not the same. If we look to the American jurisprudence, the CJS, there are pages and pages of duties, responsibilities, and also definitions of liabilities for receivers. Shown on the 65 American jurisprudence 2, I'm sorry, my referencing isn't very good. But to put here. It says on number 137, a receiver appointed by a court, while usually denominated as an officer of the court appointing him, While he is referred as an agent of the law, he holds no public office. He is not engaged in exercising a public trust. He is not a representative of the state, nor is he generally a public officer within the meaning of the constitutional or statutory provision relating to public officers. It clearly restates that receivers are not public officers. Receiver immunity is cast way too broadly also under the 20 ALR 3D 967, which clearly states that a receiver can be held liable for negligence. Under the 15.3.1 section of the OCGA, which defines officers of the court, well,
Ms. Considine,
Yes.
is your main contention that they should be held liable for either gross negligence or willful misconduct?
that in addition to not following the court orders, there are specific things in the court orders, regardless of any immunity that may be there, the fact that they did not do things that are specifically defined in the court orders, I believe there's no immunity at all. But anyway, yes?
Directed the receiver to do,
Yes.
why did you not go to the court and ask the court to bring the receiver into compliance? It's normally if we have somebody in the court system who is not doing what they're supposed to do, the remedy is, pursuant to a court order, the remedy is to go to the court, not to bring a separate action.
I did go to the court to have the receiver replaced. At that particular hearing, the defendant in the original case, Affatato, filed for bankruptcy after talking to Murphy, stayed the case, a fair amount of time went on, and then there was a point where I did go back to the court for another hearing to replace the receiver. By that time, all the assets were gone. And because of the bankruptcy declaration and the stay of proceedings, it just too much time went by. But I did petition the court to replace the receiver.
But all the other things that you're now suing for, for example, not providing reports or not allocating funds or the way you think they should have been allocated, did you ever take those matters to the original court and say the receiver is not acting in compliance with your appointment order?
No, the time and energy was spent on trying to stop the looting from Affatato to the company. There were over 80-some criminal contempt charges that were brought to the court. There are a lot of things that Affatato was doing that instead of the receiver coming to the court saying he's not playing ball, I was having to do that, and that was really what was consuming my time with the courts.
Ms. Considine, so the defendant was held in criminal contempt of the court, but not the receiver?
That is correct.
Okay.
He wasn't held in criminal contempt, although he didn't follow the court orders. I think it's still...
But you never actually filed a contempt proceeding?
No.
Against a receiver?
No, I did not.
Okay.
No. So anyway, back to what I'm trying to say. The other side weighs heavily on the Georgia Tort Claims Act, which is 50-2120. The legislative intent is that immunity is for state officers and employees acting for the public good and for responding to the public need. The definition of a state officer and employee is, they define it under 50-21 or 21-22-7, but it also specifically says that the term shall not include a corporation, whether for profit or not, or any private firm, business proprietorship, company, trust, partnership. The appointment was for a company, Murphy and McInvale. Murphy and McInvale cannot and do not qualify to be a state officer or an employee. They cannot come under the Georgia Torts Claim Act. I'm not saying that receivers cannot be entitled to official or judicial immunity. What we have to do is we have to look to the appointing order to see if the orders are for the acts for the public good, responding to the public need, or if the orders are giving a receiver judicial powers to have hearings, subpoena, swear witnesses, those types of things, similar to in the Anderson case that was cited by this court, where Anderson was not found to possess the power to subpoena, swear witnesses, compel productions, et cetera, and so on. What we need to look at is the consent order, and I'd like to take a quick look at that. I think I noted in my brief, there's more than one reference to the consent order in the record. There are notes that are on some of them that aren't the official ones, so I'm providing the certified copy. Here, the appointing order, it says a receiver shall be appointed for limited purposes of authorizing and rejecting, receiving and depositing all proceeds. There are very limited actions that the receiver is supposed to do. The receiver specifically, it says the receipt of any monies the receiver is supposed to put into the bank.
Ms. Considine, didn't the judge later, though, come back and give the receiver the full plenary powers that Georgia law gives receivers, which are similar to executors and administrators?
Yes, he issued a plenary power order to George Murphy, the individual, not to Murphy and McInvale, who was chosen by the parties. So there's a little bit of confusion of definition there, but there are no additional duties in the plenary power order. And we really have to look specifically to the order itself to define what duties a receiver has. So even though he's granted plenary powers, I think that puts the additional CJS and other responsibilities onto the receiver if they weren't already there. But the liabilities still remain for him not following these orders. Does that answer your question?
Yes, ma'am.
Okay. Number 5, it says that there were list pendants that were filed on my personal property. There's an addendum It says a receiver shall pay from model master's accounts and proceeds the mortgage payments, taxes, insurance, association fees for each parcel of a real estate as long as the list pendants is remaining. There's no way for the interpretation of this duty to be a discretionary action. It doesn't say do this, pay the phone bill, or pay this. In fact, there is no other payment that the receiver is asked to do other than these specific payments that could be a reprioritization. The receiver went through over $990,000 in the year 2009 and did not pay association fees, of which I have been sued for. He did not pay taxes, which real estate has been lost for. There is an affidavit in the complaint from Michelle Fox, who looked and saw that there were foreclosures on my real estate because he didn't pay.
Ms. Considine,
Yes.
can I ask, the reason that courts use receivers is it would take an enormous amount of time for the court itself to hear and engage in each of these detailed things,
Yes.
but the court could do that itself. Is there anything that the receivers did in this case that the trial court, had it not appointed a receiver, couldn't have done through the court's action?
I'm not sure what what a court would need to do to be, accepting taking all the money and then, like a guardian ad litem type of thing. Is that your question?
To accept money, the court could order that all the money be placed in the clerk's office and held in trust until the court ordered it dispersed. I mean, receivers like special masters or law clerks or a whole bunch of other things that courts appoint do things for the court that the court could otherwise do. And I'm trying to figure out if the court could do it and the court would have judicial immunity for it, why someone the court appoints doesn't step into the court's shoes for those purposes.
The only thing that I look to is that the court possibly could choose to do that, but in this case they didn't. They chose a receiver, and a receiver is defined as a trustee or a fiduciary, and that trustee and his fiduciary obligations are the people that have the interest in the property that was entrusted to him. So, and that's clearly defined on the CJS 150-151. It also says that general officers of the court, when they're entrusted with personal property, that they're liable to the owner of that property for negligence in the performance of the officer's trust or duty. It also says specifically neglect. So, you know, I don't think that, and understand, I'm not an attorney.
Well,
I'm doing the best that I can.
I just want you to have the chance to answer the question.
I'm sorry, yeah.
So,
Yeah.
but I mean, can you identify anything the receiver in this case did that the court itself could not have done? Or that the court, if the court had done it, would be liable notwithstanding judicial immunity?
I am not clear on what the court really has the power to do or take over. I don't know if they would have needed my consent to do that, and if they would have needed my consent, then it would have been based on the same terms and conditions that the consent order says, which means they would be liable for gross negligence or willful misconduct. I don't think that in this particular case that there's criminal activity that the court could go in and do a seizure, if that's what your question is.
Okay.
Yeah. In trying to answer the court's question, when is a court-appointed receiver entitled to immunity, he's protected from suits when the assets of the estate are at risk. And there was a case that this court put in front of me that had to do with leave of court, which the Barton Doctrine had fed into. And that's not appropriate here because I'm not looking to get the assets. A receiver has duties and obligations as a trustee or fiduciary and is not personally immune from suit for acts in the administration of the receivership. The receiver may be entitled to official immunity if the appointing order has them acting for the public good or responding to the public need. I'm running out of time, but I did want to touch on the fact that the Court of Appeals erred in requiring evidence of malice. We are at the motion to dismiss stage. There has not been discovery, even though the record has a lot of documents in it. That number one, he's not a public officer. He didn't take an oath. Public officers have to take an oath. The company doesn't qualify for official immunity under the 50-21-22-7. Murphy and McInvale were privately engaged, and that's something that the Court of Appeals seems to overlook in their engagement letter. Quick with this. That's the front page, and it's confirming that the engagement, so the appointment is of Murphy and McInvale, not George Murphy, and they are engaged as court-appointed receivers. And then the last page, it says, these persons whose signatures below agree to employ Murphy and McInvale certified public accountants. So they can't be considered employees of the state. They're actually employees of me. They also describe their own engagement here as litigation service consulting. Anyway, I have 1 minute, so I'd like to reserve that for rebuttal if possible, unless there are other questions. No. Okay.
Ms. Kingman?
Good morning. May it please the court, Chief Justice Thompson, Presiding Judge Justice Hines, Justices of the Supreme Court. I'm Joe Kingma. I'm here with Brian Spittler and Joe Hoffman, and we represent the appellees, George Murphy and McInvale. We are pleased to be before the court today to discuss immunity and actual malice. The order appealed of was the grant of a 12B1 motion, a motion to dismiss based on lack of subject matter jurisdiction. And the standard of review for the findings in that order is the any evidence rule. And I think that's important. Judge Cannon found as fact that Murphy and McInvale were both appointed as receivers, that their acts were entirely discretionary, and their acts were performed without malice and within their authority as receivers. As this court is well aware, receivers are officers of the court and servants.
Let me stop you if you don't mind. Did the court order say anything about gross negligence?
I believe that what the court order said is they were performed without malice and within their authority, but said nothing about gross negligence.
Then that's an open question, wouldn't you agree?
That is an open question, I believe, but I also believe that gross negligence is not enough to survive on this 12B1 motion.
The court order appointing or setting forth the appointment of a receiver and your engagement letter both embrace the notion that you could be liable for gross negligence or willful misconduct.
I believe that the engagement letter does say that. I don't think the appointing order does.
The original appointment order
Excuse me,
says
sir?
the receiver will not be liable except for gross negligence or willful misconduct.
I apologize for misspeaking, Justice Namias. But what...
Seems like we could agree that there's potential liability to the extent that gross negligence could be shown or complained of.
If we move on to paragraph 9 of the Georgia Constitution, Article 1, Section 2, I believe speaks to that. And I've got it up on the screen now. It says, except as provided, all officers and employees may be liable, and it goes on for ministerial functions or actual malice and actual intent to cause injury. And then it says, except as provided in this subparagraph, officers and employees shall not be subject to suit or liability. The provisions of this subparagraph shall not be waived. And thus, we contend that under the Georgia Constitution, gross negligence is not enough.
Okay, so for this to protect you, you'd first of all have to be found to be an officer or an employee, but then you'd also have to argue that the court order and engagement letter were not effective in waiving. You have to argue that that would be a waiver of this protection afforded, and that's insufficient to waive that protection.
That is correct. And in another branch of our argument, we would say because there was no order of the appointing court allowing the suit to go forward, that we are protected by that as well.
Well, the Constitution says you can't waive. If you are covered, you can't waive.
Correct.
Except through the Tort Claims Act.
I believe this court's ruling suggests that the Tort Claims Act is under the Constitution, but that there is perhaps more coverage under the Constitution than there is under the Georgia Tort Claims Act.
Can you be clear? There are several types of immunity potentially at play here, and you mentioned them all in your brief. There's judicial immunity, which is absolute as long as it's a judicial function. There's official immunity, which has this carve out for actual malice and negligent performance of ministerial duties. And then there's the immunity, statutory immunity under the Tort Claims Act. Which one applies here, and does it apply to both of your clients?
The short answer is I believe both clients are equally covered, and I've got on the slide now our attempt at analyzing Georgia law on immunity for receivers. The first branch in the right-hand corner is official immunity under the Georgia Constitution. And we believe that that immunity applies to both my clients, both Murphy and McInvale and Mr. Murphy himself. As I read it underneath the Constitution and referenced by the Constitution is the Georgia Tort Claims Act. And that is absolute immunity as we read it. But then there are others. As the court has cited us to the Arthur Anderson case, that's judicial immunity, and that is absolute immunity. And then finally, we have, the court's reference was to Stevens versus Augusta Telephone, and that is the case, one of the cases that says you've got to have permission from the court that appointed the receiver before you can sue the receiver. And we believe that our clients are protected by all of those branches.
Well, for the Tort Claims Act one, at least, how can your partnership, or I don't know if it's a partnership or corporation, how can it be protected under the Tort Claims Act because of the carve-out of the definition of what a state employee or officer is?
And that's perhaps an anomaly in the Tort Claims Act that this court has noticed before. On the one hand, in paragraph 7, it says you can't be a private corporation or a business. On the other hand, in paragraph 4, it defines person specifically as including those types of entities. And I must confess, I don't have a clear answer for the court what was meant by the legislature when they said that. But paragraph 7 specifically says, except as otherwise provided, and then in paragraph 4, it provides that a person includes private corporations of the type that is my client. And thus I would say that under the Georgia Tort Claims Act, under my reading of the Georgia Tort Claims Act, it covers both entities that are individuals as well as entities that are private corporations.
So which of these, the trial court and the Court of Appeals traveled under official immunity,
I believe that's correct, Your Honor.
which requires an analysis of whether the complaint alleges or there's evidence of actual malice or negligent performance of a ministerial act. Is that the way you think we should go, or?
That is one of the ways that we argued below, and I believe that under that route we should prevail. I would also say, and I would refer the court to some of the cases that follow Stevens versus Augusta. And if I can skip up to that very quickly. One case that's not cited in the brief is Bug v. Consolidated Grocery, 155 Georgia 550. And the Bug case holds that receivers are not subject to suit of any kind unless the appointing court grants leave. More recently, in a federal case in which I was counsel, Patco versus Lambros, 353 Fed Appendix 379, that was decided in 2007 in the 11th Circuit, and that affirmed the Southern District's dismissal for lack of jurisdiction when a receiver was sued without prior permission.
Let me get you to write a letter within the next 5 days to the clerk citing that Bug case, and I give Ms. Considine an opportunity 5 days after that if she'd like to comment on that.
Justice Thompson, we appreciate that opportunity and we'll do so. In the Patco case, the court went through the history a little bit and noted that the law had been in Georgia for many years that you needed permission of the appointing court before you can sue a receiver for anything. And it noted that the Barton Doctrine, which Ms. Considine referenced earlier, was sort of a combination of Georgia law and federal law, but that court, the 11th Circuit, held that under the Barton Doctrine, which applied in both Georgia cases, which it cited, as well as in federal cases, that you have to have permission of the appointing court before you can sue. And when you think about the public policy that's involved here, that really is important, because if you're a trial court and you've got a mess of a case, and frankly, in my experience, receiverships are a mess usually, and the court doesn't have time to handle that mess day to day, so they appoint a receiver. And if that receiver, at the same time they're trying on behalf of the court to sort out the complexities, is also defending itself against an unsatisfied investor or owner of the receivership, it's just impossible to get the court's work done. And I believe the Barton Doctrine reflects that both the federal court and the state court require that there be protection for receivers. And the judge that's best qualified to rule on whether a case against a receiver should go forward is the trial court that appointed it. And thus, we contend that under Stevens, which could arguably be read as only applying when the suit is against the assets, But when viewed in the light of Bug and Patco, it's clear that you've got to have permission of the trial court before you can sue a receiver for anything. And thus we submit that under that line of cases as well, the judgment below should be affirmed.
Explain the rationale of that. So the judge, if the original appointing judge says, yeah, you can sue the receiver for simple negligence, then it's okay?
I don't think it's okay. Well, I think then it would be okay to sue for simple negligence. But on the other hand, our motion would be following promptly saying, that suit is barred by immunity under the Constitution. And, if that order is not granted, then it comes up on appeal. That would be my analysis.
Federal court there's a federal statute which has an exception to the Barton Doctrine, which is as a course of business. So if you're a receiver of a grocery store chain, as a slip and fall case, then you don't have to have leave of court in that instance, correct?
That is correct.
Does Georgia follow that also?
There aren't a lot of cases, obviously. My reading of it is that's true. If you're suing a receiver who's operating a business like a store and there's a slip and fall at the store, you can sue the receiver who is in fact the business.
In his official capacity, not
Correct.
individually.
Correct, and that a judgment, if obtained there, would go against the assets of the receivership, obviously. That's my reading.
All this is under the heading, as I saw it, was lack of subject matter jurisdiction.
That was the nature of our 12B1 motion below. Yes, Justice Melton.
I'm wondering if that's the right label to put all this under. The court has subject matter jurisdiction.
We contend that because there had not been a showing that there was an actual intent to injure the appellant, Ms. Considine, and there wasn't any showing of any ministerial act, there was no jurisdiction. And our understanding of this court's rulings, as well as the Constitution, is that's a preliminary investigation that has to be concluded before the case really starts. And thus, we contend that this does roll up under 12B1.
There are a number of cases under the Tort Claims Act statutory immunity that say that's a subject matter jurisdiction issue. But part of that is the Tort Claims Act itself says the court shall have no jurisdiction if you don't follow the Tort Claims Act and there's a waiver. Is there similar case law in Georgia for either judicial immunity or constitutional official immunity?
I must confess, Justice Namias, I don't know the answer to that question, but within 5 days we will give you our best analysis on that if that would be helpful to the court.
Go ahead.
Counselor, on the motion to dismiss, saying that there was if the standard is going to be official immunity and one of the exceptions is malice, which allows a suit, and we're in a notice pleading state, and the plaintiff alleges that a malicious act, alleges there's corruption, alleges that there's criminal theft. What point does wouldn't it have been incumbent upon the trial court to have a hearing to determine if there was some good faith basis for those allegations?
Yes, I believe that's correct. And as a matter of fact, the court was going to schedule a hearing below, and counsel for Ms. Considine, who was represented at the time, said they didn't want a hearing, they just wanted a ruling. And thus there were affidavits that were before the court, but there was no actual hearing. But I would also cite you to the Murphy versus Bajani case that I have up on the screen now. And this court said in Murphy versus Bajani, a deliberate intention to do wrong, such as to constitute the actual malice necessary to overcome official immunity, must be the intent to cause the harm suffered by the plaintiffs. In contrast, plaintiffs' allegations of malice or of deliberate acts of wrongdoing done with reckless disregard for the safety of others. As such, they do not allege the actual malice necessary to overcome official immunity for discretionary acts. So in Bajani, this court said all that kind of stuff that was alleged by the appellants in this case, that's not enough. They didn't allege and they didn't give any facts to show that my clients intended to hurt them, because there are no such
If
facts.
you're under the Tort Claims Act and subject matter jurisdiction and a motion to dismiss under B1, then it's up to the trial court to decide how to resolve it as a matter of evidence, and then we have to defer under the anti-evidence standard. But if it's not subject matter jurisdiction, and we'll find out what you think of that in your supplemental brief, but if it's not subject matter jurisdiction, you just lose on your B1 motion, right?
I'm sorry, if you say if
If
there's,
judicial immunity is not a matter of subject matter jurisdiction, it's a defense, then you file a motion to dismiss based on judicial immunity under B1, that would be denied. The court would have jurisdiction, you would have to file a motion under B6, right?
I believe that is correct. If the court has jurisdiction, then we have to go under B6.
And if you get under B6, we're into notice pleading, and if the plaintiff alleges malice, you lose.
I would argue that under Murphy versus Bajani, we would win because they didn't plead it.
So you would say that we would need to look at the actual allegations of malice to see whether they are sufficient as a matter of law to state a legal claim?
That is correct, and I believe under this court's standard in Murphy versus Bajani, what they pled here is virtually identical to what they pled in Murphy versus Bajani, and this court said in that case that they went out on a motion.
But you filed a motion under B1, and you won below, both in the trial court and the Court of Appeals under B1. Did you file a motion to dismiss under B6 and
We
get
did.
a ruling on that?
We did the first time around, as the court will recall, we filed one, they dismissed. And the first time around, we filed under B1 and B6, I believe, and they dismissed, they refiled, and we came back under B1 this time and didn't come back under B6.
So if you don't win under B1, the case should go back and you should litigate under B6.
I believe this court has ruled that there is no wrong for any reason standard. If there's a right for any reason standard, I'd like to think we could prevail because of the Stevens line of cases.
Your assertion is that fraud has
As I read the court's rulings, it may be even stricter than that. As I read Murphy versus Bajani, it's even stricter than fraud with specificity. Here they say, the court says, must be the intent to cause the harm suffered by the plaintiffs. It's not that they can just say a time and a place, but they have to plead and show facts supporting intent to cause the harm suffered by the plaintiffs, and they simply fail to do that. And that is one reason we came back under 12B1 this time around. It's because we think they clearly, under this court's own rulings, didn't make it under that standard.
And I just want to make sure one other point, if I may. You would say, as I hear your argument, that the court's language in the appointment order and in the language in your client in the engagement letter saying gross negligence is potential subject for liability, that language has no effect whatsoever.
That is correct. We think that immunity cannot be waived. And if I could, because I realize my time is very short here and I want to answer all the court's questions, but I would also like to point out that this court has ruled that it shouldn't reverse based on arguments not raised below. And we think this discussion is great for practitioners and great for receivers and great for those who have immunity because we seek the court's clarity on these issues.
Just one more question
Absolutely.
about the Tort Claims Act liability. Under the Tort Claims Act, if your clients are considered state employees or officers,